Good afternoon. Welcome into the Senate Committee on Government Operations meeting for Friday, February, February in a way, January 16th, 2026. So we're at the end of our second full week in the 2026 session. Two items to take up today. We did have, for those of you that really pay attention to the agenda, we had a security training event that was postponed, and we'll take that up, I believe, next month. Up first today is S-196, an act relating to property tax sales. Cameron Wood, who's our legislative counsel on this particular piece of legislation, is with us. Senator Clarkson, who's the sponsor of the bill, is meeting in another, I think in the Senate Pro Tem's office, actually, and she'll be joining us momentarily. But I do want to welcome in former state senator, of course, once a senator, always a senator, Senator Cheryl Hooker from Rutland, who was a member of both the Senate and House at one point in her political career, and has gone back to Rutland and is on the board of Alderman right now. And so she's involved in local municipal activity, and we served together for many years. Cheryl, it's always good to see you. Welcome, and thank you for taking time with us today.
Well, thanks for having me, Brian. It's good to see all of you.
And I think everybody at the table, if not, we could certainly go through and introduce ourselves.
Well, maybe when John gets.
Yeah, okay. Excellent point, Senator. So yeah, we'll reintroduce ourselves at that point. So I know from actually doing cemetery work with you earlier this summer is when you first brought this to my attention. And I did promise that we'd at least take up testimony in the committee to address this. So you and Senator Clarkson, I guess, have put this bill together. And if you could just sort of run us through why you wanted to bring this to our attention, that would be great.
Okay, thanks, Brian. I'm Cheryl Hooker, Rutland City. This bill would make a couple of small changes to 32 VSA, the tax sale bill, or the tax sale law. It would simply allow people who bought a property in a tax sale to go onto the property and secure it, to keep it from deteriorating any further, especially if the property is uninhabited. Secondly, it would shorten the kind of redemption time that the previous owner had to make good on his payment or her payment of taxes. The reason I got involved in this is very personal, in that my son, in August of 2023, was the successful bidder at a tax sale. He knew he had to wait one whole year before he could go on to the property. The property was uninhabited at the time, and it had open windows that you could see. I mean, you couldn't go in to check anything out, but the town that he purchased the property in was allowed to go in to kind of secure it. And they sort of did put up some blocks in a window that was open, and that was about it, I guess. He waited the whole year, and in August of 2024, he got a tax collector's deed, which allowed him to go onto the property and to start doing whatever he wanted to do with it, because technically, I guess it was his property. So for about a month, he and friends and family were there to clear out the many vehicles that were on the property, to go into the house to see what kind of damage was done, and to start renovating what he could. About a month after the 1 year wait, he was notified that the previous owner had filed for bankruptcy. And apparently, the law says that the previous owner has the right to file for bankruptcy up to, I believe it's 5 years after the sale. So, so for more than a year, he was in litigation with the bankruptcy. He had to hire a lawyer and pay his share of the costs. He was charged with the town, so they each had to have lawyers. And the person who had not paid taxes for the third time, this was the third time that this property had gone up for a tax sale, was able to get legal representation from Vermont Legal Aid. So for 2 years, my son's been paying legal fees. And finally, in October of 25, he was told that the judge had dismissed all of the charges, 7 charges that were brought with regard to the bankruptcy, and that he indeed owned the house. The previous owner appealed. So now my son is still waiting to be able to do something with this property that he felt was an avenue for him to finally own a house of his own. And he moved into the house because when he wasn't there and the house was seen as uninhabited, the insurance on it was $600 a month. So he had paid that for the first 2 years that he had the property, and finally decided that he would do what he had to do to plumb and to heat the residence so that he could move in and reduce at least the rate of payment for insurance. He hasn't been able to get a loan now, a mortgage on the property, because it's in litigation. And so he really can only do what he can afford to do from what he has in his own reserves. So I guess I'm here because I think that, yes, people need to have the opportunity to redeem themselves if they fail to pay their taxes. The person that my son got this property from had failed on three separate occasions. From 2012 was the beginning to 2025. And within that time, 3 times he had failed to pay his taxes. 3 times, the first time he said that he made arrangements for a payment plan, which he didn't adhere to. Second time, he said he didn't receive the notice about the tax sale, and it was because he wasn't living in the property. He was living someplace else. The third time, they finally got the notice to him by sending it with a sheriff or someone to the place that he was living. So I understand that people need to have time to remedy their situations, and I think that that's something laudable. People run into difficulties and they need help. There's also the other side of the scenario where the person who's buying the property also should have some rights to go in and secure the property so that it doesn't deteriorate any more than it already had. That person then should have some understanding that what he or she is going to do to that property to enhance it is going to be for the good and for something that they can count on, at least after a time. The redemption period is a year now. In this bill, it would reduce that to 6 months. Within that time, there should be plenty of opportunity for people who have defaulted on their taxes to make some kind of a plan so that at least that they're in good faith doing something that would move this along. And then going back to just securing the property, it just seems like a logical thing to do, especially in this time that we have such a housing crisis and we're in need of more suitable places for people to live, to allow property to just deteriorate simply because you're waiting for somebody to get their act together. It seems like it's counterproductive. So, again, um, I'm here because for a personal reason, but this doesn't just affect my son. This affects individuals who feel that this is an avenue that they can use to have a home of their own. It affects people who are willing to go in and fix up different places so that people who need housing can get into suitable apartments. So I'm hoping that you'll look at this and make those changes. Ideally, I would like to see a situation where if you're going to file for bankruptcy, you have to do it at least within that um, time that you have to make arrangements for, getting yourself settled in this situation. So that's it. I mean, the law as written or the bill as written would say the person who was the winner, if you can call it a winner, at the tax sale would be able to go in and secure the property. And secondly, that the person who defaulted on taxes would have 6 months to either come up with a plan or to pay off the tax bill. Once again, I know bankruptcy is probably not in the purview here, but it would be ideal for that bankruptcy to occur within that time. So I guess that's all
Okay.
I'd say.
Thank you very much, and I certainly share your son's frustration. I'm assuming he's still frustrated with the whole situation. And I'm gonna have Cameron Wood run through the bill. But now that we're all here, just for Cheryl's purposes, let's introduce ourselves and we'll start with Senator Moore.
Senator John Morley from Orleans District.
Nice to meet you.
Harry, look at her here and she can actually see her view.
Okay.
Hi, Cheryl, Allison, and thank you. I apologize. I was in the principal's office
Oh.
discussing the bill.
In Woodshed, I
That
know.
is the only reason that would have kept me from introducing this bill, because I really wanted to be here, and I apologize to my chair and to you.
Senator Colin Moore from the Rutland District. Cheryl and I are very well acquainted. We'll get to Lynn in just a second.
Senator Tanya Bielski, Chittenden Central. Nice to see you.
Nice to see
Hi,
you.
Senator Emeritus Hooker. This is Senator Becca White, Windsor County.
And our committee assistant is Lynn Jacoboskis.
Hi, Lynn.
I don't know if you can see
Committee
me.
assistants are very, very important.
Important. Okay, Cameron, can we walk through the bill?
May I just ask a question?
Certainly, Senator.
As Cheryl, you did a great job on the bit. I would just say we passed the provision of being able to secure the property last year or the year before. I can't remember which. And then I would also appreciate, as you go through this bill, what happened, because we thought we had done that. We had active discussion, very good discussion in here on that. And I just am curious what happened.
Right. For the record, Cameron Wood, Office of Legislative Counsel. Believe most of you know me, but nice to meet you, sir. My portfolio areas cover housing, consumer protection, retirements and pensions, but I also cover bankruptcy matters. And as this as was mentioned, as somewhat involved, bankruptcy proceedings that came to me. And so now I think I get the pleasure of covering tax sales. So happy to be here.
We're thrilled to have you twice in one day.
For you. Yes. I'm gonna try to share my screen. I just requested permission and I will pull the bill up and so we can begin to walk through. Okay, here we go. Okay, so we have S-196 as introduced. This is a 9-page bill, but the changes are relatively straightforward. So I'm not going to walk through this line by line. I'll get to the changes here in just a minute. I will, before I jump in, I will just make a few quick comments. This is the section in Title 32. This is under, indebtedness for taxes, and this is regarding levy and notice of sale for tax sales. This section has been amended multiple times in the past 2 sessions, 2024 and in 2025. In 2024, the General Assembly added provisions that must be in effect before a municipality can go through the process of a tax sale. Specifically, you added that the debt had to be owed for greater than a year. You added that the individual debtor had to be given an opportunity for a repayment plan. You added additions to the notification requirements to ensure that the debtor was made aware of the sale.
Oh my God, I
And
remember
then-
that was a long discussion.
Yep, and then you added that specific notice provisions, and I can just get there so you can see it. This information here at the bottom of page 3 and the top of page 4, you require this following statement to be provided. And then you require that information regarding translation services must be included within that. And then last year in 2025, you added in Act 73, you put in that the outstanding debt, there has to be a minimum of $1,500 owed. And that's up here on the first page, line 8. So just commenting that those are some amendments that you all put in place over the past few years. And so those provisions have to be met before you can even proceed with the tax sale. Okay. As was mentioned here, there's nothing that is being amended regarding those provisions or regarding the tax sale process. The amendments that this bill would do are about securing the property after a tax sale has occurred, which is going to begin on the middle of page 4. So we're still in the same section. Everything in subsection A is what I mentioned: reasonable opportunity, 1 year, 1,500 notice. Here's everything that has to be done to do the tax sale. Then we get to subsection B. Current law is if the warrant for the tax sales has been recorded, the municipality in which the real estate lies may secure the property against illegal activity and potential fire hazards after giving the mortgagee lien holder of record written notice of at least 10 days. This bill proposes to add damage from exposure to the elements and deterioration into those provisions. Now, this is for a municipality, not for the tax purchaser. I'll get to that in just a second. But that's the first amendment that we're making to that section. And then the remainder of this is, as I mentioned again, the information that has to be provided and the reasonable opportunity to pay for the debtor.
Can I just interrupt for a second?
Yes, sir.
So on line 14 of page 4, one of the provisions includes the requirement that there be a written notice at least 10 days prior to such action. When Senator Hooker testified, one of the things that happened was that the municipality could have well sent that, but since the person in question wasn't living there at the time, never received it. So is there any other reference to, I understand what written notice means, but what if it's never accepted or got to that person?
So
We spent a lot of time.
one thing I'm going to do, I'm going to move up a little bit. I'm gonna
Okay,
move back
yep.
up to subsection A, and I'm going to talk about some of the things that you all changed.
Yeah, we changed that.
All right.
In subsection A regarding notice. So in 2024.
Yeah.
As I mentioned, when you added the 1 year period, added the repayment requirement that the individual be given an opportunity to repay, you also added
I think I found it.
3,
3 and 4.
3, and C here.
Yeah.
So then now this is notice for the tax sale itself. So on page 3, you added in subdivisions B and C. So the Taxpayer has to be given written notice by certified mail of the tax sale at the last known address 30 days prior. And then if notice by certified mail is returned unclaimed, it used to be you had to provide notice by first class mail as, required by the rules of Vermont civil procedure. You all added in that now you must provide notice by email. If you have the email address, and you have to affix notice to the front door. And then
And I was again, and I actually think we're refreshing my memory, and I don't want to dive deep into this conversation again, but what if there is no front door because the property is a vacant lot?
Oh, yeah. Oh,
We addressed that.
I don't, but I don't see it here, and I don't remember how we addressed it.
They,
I was not here, so I do not recall the conversation, or I have not listened to the conversation. I'd be happy to go back and check and see if that.
but I think it's provide personal service.
Previous council,
I think it's line
or
2.
what the process would be.
Okay, thank you.
I think,
Mr. Chair, to answer your question. If the individual is not living there, as long as the municipality is complying with what's on this page, then there should not be an issue. My understanding, and I want to be somewhat careful here because as was mentioned, this appears to be an ongoing live case. My understanding is this property in particular that was referenced, the municipality tried to do a tax sale, and that tax sale was made void because the municipality did not comply with the notice requirements in the law. So I don't know that I don't think the individual is going to have a defense simply to say, I don't live there, therefore I didn't get it. If the municipality can demonstrate that they've done what is required of them by law. Okay. But I do know, and I don't know the specific facts of what happened. I do know there was an instance where the municipality tried to move forward with the tax sale that was made null because they didn't comply with the notice requirements. They had to go back and do it.
Okay, thank you.
Okay, so moving to section 2. So I'm going to bring us all the way back down to page 6. And this is where you'll see section 2. This is a form that has to be advertised for the tax sale. And as you can see here on line 19, it's just reducing the notice of the redemption period from 1 year to 6 months. As was mentioned, you go through a tax sale. The tax sale is made. Someone purchases the property at the tax sale. The individual debtor then has a year to redeem that property from tax sale. So the person purchasing it doesn't own the property at that point in time. The debtor still owns the property. It is still theirs. They have that 1 year to redeem. This is reducing it to 6 months. And so in this instance, it's just adding that into the notice that goes to the individual. Section 3, this is where this would be adding in a section into this chapter where, as I said earlier, the municipality can go in and secure the property. Under this language, this would allow the purchaser to go in. So I'll just read this. It's a short section. After providing the mortgagee and lien holder of record written notice at least 10 days, similar language to what the municipality is required to do. The purchaser of the real estate subject to the subchapter may enter the property to secure the property against illegal activity, damage from exposure, deterioration, potential fire hazard, same list of conditions. Senator Clarkson, you had asked about this. What I was able to find, and I have not done an exhaustive list of bills that came out of your committee here, but I was able to find that this similar language was introduced last biennium, but it did not come out of this committee. Now, whether it was included into something else, like I said, I haven't exhausted all
I
of
was
it.
included in the work that did come out of this committee and made it through and the provisions you talked at the beginning.
I'll go back and check.
Because we began here. This is where Cheryl and I began 2 or 3 years ago. We began on being able to secure it from animal damage, weather to damage. I mean, that you're not allowed to secure the property that you have bought and paid for.
What I can do real quick, once I walk through this, I'll stop sharing and I'll see if it was in 629, which ultimately became 106.
Yeah.
Thank you.
Yes, Senator White.
Thank you, Mr. Chair. So in this section, you don't if I was someone who purchased a home in a tax sale, the person had set up a financial payment plan, but, you know, with intent, you know, I could go in even if they had set up a financial plan at that point, like going into someone's home.
So the repayment plan would have to occur before the tax sale.
Okay,
But after the tax sale has occurred, let's say you're trying to come up with the money to cover what's required under the redemption. You have to pay the amount that was paid for the property at the tax sale plus interest. And so if you're working to come up with that, under this language, you wouldn't be able to prohibit someone from coming onto the property. I will comment a few other quick things. There is a limitation. I mean, it is, you can only go on to secure it against illegal activity, damage, deterioration, fire hazard, etc. There's nothing there about whether an individual is still living there.
And we can clarify.
yeah, that's kind of my,
Yes, ma'am.
yeah, I think that is, you've hit on my exact point, is I just don't want to set up a situation where there's people who are on the property being told that maybe someone's putting up tarps or, you know, some kind of change to the property. So I'm wondering if is something that could be added to this, like if they went with the sheriff or like law enforcement and go, okay, well, it's a different, you know, or like if they felt I think that might be a good addition. Is there any requirements of having, like, when entering a secure property, this person could just go solo? There's no requirements in this bill now.
No.
But could we add something like with potential?
Yes, ma'am.
Thank you.
Senator Bielski.
I think if the property were vacant, I could sort of see that, but if someone's living there, I feel like there is no securing it against the elements, like someone's living there, I feel like at that point, no, you shouldn't be able to go into their home.
Yeah, that's a good thing. Yeah. So maybe some points on there.
But there must be law about this. I mean, this must already be, when a property goes to tax sale, is it still inhabited? I don't believe it is. I believe, so we should clarify when it is sold. I believe it is that it is not, people don't continue to live in a house that's already been sold. So that we should clarify. And I would also love to clarify the second piece of that, because it's, yeah, obviously you don't want people moving in when there's somebody there. But my understanding is that once it's gone to tax sale, no one is living in it after the tax sale. However, and maybe it just should not be called a tax sale. Maybe it should just be called a tax investment. So the question I have is, how much time does an owner have to pay taxes before it does go to tax sale?
It's a year right now.
No, they have a year after the tax sale. How much time do they have before it goes to tax sale to cure the tax they owe?
So I will double check on if somebody's living there.
Yeah.
The first question.
And sadly, Chris just left, so.
The outstanding taxes must be due for at least a year before the municipality can bring a tax sale.
Right.
So the tax sale also has to meet a minimum of $1,500. So the taxes could have been owed for many, many years, however long it took you to get to that $1,500 threshold. At that point, and again, that was just added last year, but it's a minimum of a year, but it could be much longer than that. But at a year, if it's at least $1,500, if the individual's been given the opportunity to enter into a reasonable repayment plan, at that point, the municipality can move forward with the tax sale.
Senator Bielski.
Is there any legal or statutory definition of what a reasonable repayment plan is? Who gets to decide what's reasonable?
I do not recall in the statute section, I do not believe that is defined. There is.
I think it's the
So it says. Pardon the scroll here, we're gonna go all the way back up to page 5. Yes.
Yeah.
So
I
it says
think-
here, when establishing the plan, the municipality may request these pieces.
Oh, okay.
And they have to consider the following: the income schedule of the taxpayer, the taxpayer's tax payment history, the amount, etc. But other than that, there is nothing currently, it's not a defined term. So municipalities could proceed differently.
Yeah, I think, and perhaps I'll yield to Senator Moore, but they have delinquent tax collectors in most municipalities. I think they have the option or the flexibility to determine for that municipality what their policy is.
Yeah,
Yeah.
and town managers do this all the time.
So what lots of times happen is, once we turn over those delinquent taxes, it goes into it leaves the village of Orleans and goes into the delinquent tax collector's purview. So it's out of the hands of the village at that point, as far as the managing of it and all that stuff. And then Senator, will set up a payment plan. And just so you know, lots of times those payment plans get broke too. So that causes a bunch of other
So
concerns.
that, our municipal manager used to do those plans and would work out plans with the individuals.
Yeah.
I mean, these are all individuals we know because they're published in our town reports.
All of them.
And it is, you know, all of us, homeownership is a responsibility. You know, it's not, and it's hard to see those of us who do pay our taxes. And even if we have to pay them in staggered amounts, to have to see people year after year after year not paying their taxes and getting to continue. This is really a challenge.
It's
So,
tax budgets too.
yeah, and then and the towns suffer as a result as well.
Go ahead, Kevin.
Other, I believe, remaining provisions, so just bring us back to, I think we're on page 7 here, section 4, so this is the redemption section itself. So this is just reducing, as was mentioned, the redemption period from 1 year to 6 months. And then you have,
Sorry, what page you on now?
that was on page 7, that whole section, that the only amendment is there on page 7. Then you get to page 9 where there is. The amendments here do not apply to property that is subject to notice of sale prior to July 1 of 2026. You want to have kind of a date and time at which previous provisions apply, new provisions apply. That section is there. A few other just quick notes I will comment on for awareness. You've talked a little bit about bankruptcy as well. You know, the kind of fact pattern leading to this was involving some bankruptcy proceedings. Bankruptcy is primarily governed at the federal level, so there's not really much that the state is going to do to amend how federal bankruptcy proceedings work. An individual who has their home subject to a tax sale during that redemption period can file for bankruptcy and potentially keep the home, even if it has been sold at a tax sale, if they're going through a personal reorganization. And then I also know some issues that were brought up subject to the case that was brought up by Senator Hooker. There are also certain look back periods that apply or can apply. So when you go through a bankruptcy proceeding, bankruptcy courts will look at certain transfers of property that happen prior to the bankruptcy filing to make sure there isn't any fraudulent activity, fraudulent transfers, things like that going on. My understanding was those were some of the arguments being made in the case that kind of led to this. So I'm just flagging that for you all. It's not always a clean, you have a tax sale, you get a year period and it's done. Somebody walks away clear, you know, free and clear, especially if somebody involves bankruptcy court, either immediately preceding the redemption period expiring or shortly thereafter. Then you get into a lot of, you know, challenging federal conversation when that happens. This would reduce it from 1 year to 6 months, as you've heard. The only other comment that I will mention for your awareness, I said in 2024, Act 106, you all made some of those initial amendments regarding the 1 year taxes must be owed, providing the reasonable opportunity to enter the repayment plan, etc. You also had a task force look at additional changes to the tax sales process. There is a report with which looked at multiple different issues that I won't necessarily go into here. unless you would like me to. I did not staff the report or anything like that, but it's here in case you all want to
Yeah, I'd
review
like to at
it
least see it.
or
Yeah,
want me to come back and walk through it.
Sure, yeah. We'll take more testimony.
I will send it to you also. You have it at a minimum in your invoices.
Senator Clarkson.
So I also, and I'm sorry, Chris had to leave. Chris Dealey was here from the bank. Because I'd like to understand the interplay on the bankruptcy piece here too. Not all people who are delinquent in taxes declare bankruptcy, right? I mean,
Correct.
so, if they do, so I would appreciate understanding the interplay of declaring bankruptcy and how it protects you in the years preceding actually getting to tax sale. Because what I think we all need to remember and appreciate that with many of those tax sales, these are properties that have been in tax limbo for quite a long time, or tax, some challenges on taxes. If you declare bankruptcy in the course of that proceeding up to the tax sale, because we're talking about point of tax sale, the 6 months after that, what can people do to protect themselves leading up to that moment? Does bankruptcy protect you and delay the tax sale? I mean, all those, I just have questions about that interplay of bankruptcy and tax sale.
At a minimum, what happens when you file for bankruptcy is all collection activities have to stop immediately, including municipal tax sale collections. So if, let's say you receive a notice that the municipality is going to proceed with a tax sale, you're receiving that first notice. Keep in mind, the municipality has to publish the notice in the newspaper, and they have to do all this other stuff. So let's say you get that piece of paper and it says, we're proceeding with a tax sale. You immediately go and file for bankruptcy. That tax sale has to stop immediately preceding the outcome of the bankruptcy case. Separate situation.
How long is that? Sorry, but at that moment, how long do they have to resolve that bankruptcy?
Oh, I don't know. I don't know the average time of bankruptcy case. I think it's going to depend on whether you're doing, chapter 7, are you liquidating everything? Or are you doing a chapter 13 where you're doing a personal reorganization? It's really going to depend on the case.
But that all happens pre-taxing.
It could.
Or
So then
in
let's
course.
let's say after tax sale, the same thing is going to apply. If town has sent you a notice, we're proceeding with the tax sale, they move forward, they sell it. It is purchased by someone else at that point, and you're within the redemption period. You still own the property, it is still yours. And so you file for bankruptcy during that period, the same rules are going to apply. Everything regarding that redemption period will stop until the bankruptcy case is resolved. And as I mentioned, what someone can do in that instance then is they could file for a chapter 13, which is a personal reorganization. And they could make agreements with the bankruptcy court to pay back their delinquent taxes, pay back delinquent mortgage on the property, etc., and keep the property. And then they would be given up to 3 to 5 years, depending on the case, depending on the agreement they've made with the bankruptcy court to pay those debts back off. So it's almost another bite at the apple for the debtor in that instance.
I know. I think this is what's making me nuts about this is that, in many of these cases, there's been a lengthy period of time where the owner has had the obligation to pay taxes and they have failed to do so for whatever reason. I mean, independent of the reason. I understand being able to declare bankruptcy then, but I do not think it is fair to sell property to somebody else and then be able to declare bankruptcy. That just seems to me, then we have to rethink this altogether, because then it really isn't the sale to somebody else.
Well, that's not a question for Cameron.
No, I'm just saying, it
Well,
just seems,
So bankruptcy's in my portfolio.
yeah, it is.
But
Okay.
I'm asking.
But what I would respond and I would say is you're not going to, because bankruptcy is governed nearly exclusively by federal law, you can't change that piece of it. So,
Senator White, you have a question.
Oh,
Well, I was gonna say, but that's the purpose of the reduction of the redemption period. That's kind of why, in working with you, Senator, that's why we drafted this way. If you reduce the redemption period, you're somewhat reducing that time period
Yeah.
in which that occurs, or which the individual has the right before the property transfers to somebody else.
Yes.
Is that right?
Thank you, Chair Collimore. Yeah, for this bill, and I think this is where probably Senator Clarkson and I have some of our most challenging differences. Because I think, as I mentioned to this committee in previous years, my family had their home sold in tax sale. When my parents were going through their divorce, it was a bad year. You know, it wasn't a long period of time. It was like 18 months of a struggle. Luckily, my mother was the purchaser of my family home because no one else bid during that tax sale. And I thank my community for that, because it let my family not be unhoused. So I'm really grateful for that.
So I just on that, did you live in the house up to that tax sale point? And at the tax sale, you were still living in the house?
No, we had vacated. It
Yeah.
was,
So
but
I
we had
do
lived
think
there
there's a
for a
requirement
period of
of tax.
time. Well, my situation is more complex because my mother purchased the home. So she purchased the home my father had lost in tax sale. So where I lived was a little bit, you know, kind of in the mix. But I have a lot of difficulty with this bill. I have a lot of difficulty with this bill. I'm open to us considering it again. I want to understand the report because I thought we weren't going to make new changes until we had fully reviewed that. So I'd like to make sure we go into that. The biggest point of sticking for me, where I will be unable to support this, but I'm open to the general concept, is I'm uncomfortable with moving to a year from 6 months. Or moving
No.
1 year to 6 months. Yeah. To make the time shorter is a hard stop for me. So I wouldn't be able to move forward with that. But I do really appreciate the sections around folks being able to secure from damage and exposure. I think that's a big one. We should do that. Oh, look.
So I had a question too. What happens to the money that the purchaser puts away in the tax sale in this ongoing process? Is it put in a bank in limbo? Does it have to be reimbursed if the whole thing goes sour by the municipality? Where does the purchaser's money go?
That may be a better question for a municipality. I don't know. I don't recall in reviewing the statutory sections, there's any, statutory requirement that a municipality has to put it in escrow or anything like that. The individual would get their money back, assuming the individual redeems.
Okay.
Because if the individual redeems, they have to pay interest on that money too. And I think it might be 1%.
It is per month.
Yeah, I believe it's 1% per month.
Okay.
So,
Well,
So
4%
you-
a year.
so you have purchased it at the tax sale, and again, you have that 1 year redemption period. The debtor within that 1 year has to pay you what you paid for the property plus that interest.
Okay.
And then again,
1%.
I think
1%, if it's 1 year.
It adds up. It's not 1% a month.
The statute says
1%
1% per month.
plus
Yeah,
1%.
and then, if you move into a bankruptcy proceeding, then again, my assumption is the municipality has that money and they're gonna give it back to you, assuming you don't gain the property after a bankruptcy is discharged.
Okay.
So in theory, the person purchasing the property at the tax sale isn't lost anything other than the fact that they may not.
Right. And that's what I wanted to have cleared up. Okay. Well, it sounds like we probably need to take some more testimony. I'd like to see that report. I think Christelia would probably want to come in and offer the Vermont Bankers Association perspective.
We include Vermont Legal Aid. I think they give
Yeah.
us.
Your lane would be good, and I also think that it would be great to have a town manager, who's worked
Yeah.
through this, and worked on, some deals. I know we have you're our secret edition here.
Let me just copy that down. So town manager, just for.
Or maybe delinquent tax collector, or whoever.
I don't know, or whoever.
That's not always a
Good tax collector is, legal aid, I think somebody who's, in addition to Cheryl's son, another person who's bought properties at tax sales. I think we have to maybe call it something else, because it's not a sale. It's like a right to purchase. It's like a
Yeah.
first refusal. It's not, at the moment, it's not a tax sale. It's not a sale. It's a opportunity.
I think if we're gonna start hearing from lots of people who've experienced purchasing at tax sale, it might also be helpful to hear from people who've lost their homes.
Oh, absolutely. That's why the legal aid and.
In addition
Yeah,
to.
please do
legal aid.
it.
Yeah.
So,
In addition to
For
the
just
fact
the
that-
trees.
and I think to Senator Hooker, I'll just mention, you are well aware, Cheryl, that nothing in this, well, relatively rare would it be that something that's introduced gets all the way to the finish line without even changing a comma or a period. So and this committee is very good at, I think, being very objective in terms of what we do, what we take out of a bill, what we add to it, the testimony that we take. So we're going to take this up again and see if we can't come to a point where all of the stakeholders say, yeah, okay, that makes sense to me too. Let's go further. But I appreciate his frustration. I can't imagine, I would have gone out of my mind after 2.5
That's
years.
a situation.
No,
It's
he's now.
a sense, I think, a sense of balance here, you know?
Yeah.
Yeah,
Certainly, I certainly appreciate that. And if you can come to consensus, bravo.
That's our job.
Very good piece.
Cheryl, it's now been 3 years, is that right?
Started in 2023. It's going on.
Yeah,
Yeah. And,
Yeah.
you know, I mean, this case, the bankruptcy in this case took place after the redemption period.
Sorry, after what?
Now it's an appeal. So the
After
bankruptcy
the
has gone through,
After the year?
it's an
How
appeal.
did I-
And, you know, it could be 2 more appeals, I guess, because right now it could go to district court, it could go to.
Is he
Supreme
ready to
Court.
sell it?
And
But that's out there, really.
Okay, well, thank you, Cheryl.
Thank you for
Have a
taking.
great
this.
Friday and a great weekend. Good to see you as always.
Good to see all of you.
Bye, lovely lady.
Bye. Bye, dear. heart.
Yeah.
All right, so we'll put this on the calendar for maybe next week or maybe the week after. We'll take it up again for sure. And why don't we take a 5-minute break before we launch into what hopefully will be our final event of the day.